All right, hello everyone, and welcome. Today we are diving into a really fascinating and honestly pretty complex area of private international law, matrimonial causes. This is where global lives and local laws collide, and it creates some of the toughest legal puzzles you can imagine.
So, to get our heads around this, let's start with a little thought experiment. Picture this: an Indian couple whose permanent home is in India goes and gets married in a civil ceremony in London, okay? Now, picture another couple, also from India, who want a fast divorce. They fly to Nevada, stay just long enough to be considered residents, and get a divorce decree from a U.S. court. Now, the big question is, back home in India, is the first couple actually married, and is the second couple really divorced? The answers, as you're about to see, are anything but straightforward.
So here's how we're going to break this all down today. First, we'll cover the basics. What even is conflict of laws? Then we'll get into the specifics of marriage, looking at its form versus its essentials. After that, we'll tackle foreign divorces, why some foreign judgments get rejected, and this really strange problem called the limping marriage. And finally, we'll talk about what the path forward might look like.
Okay, first things first. Let's get our bearings. What in the world are we talking about when we say private international law, or as it's often called, the conflict of laws? Think of it like this. It's the rule book that kicks in whenever a legal case has some kind of foreign element. A contract signed in another country, an accident that happened abroad, or a marriage celebrated overseas. It's the system that helps a court answer three crucial questions. 1, which court gets to hear this case? 2, which country's actual laws should we apply? And 3, if a foreign court already made a decision, are we going to recognize it here? The legal scholar at Cheshire really put it perfectly. It's that part of the law that tells a local court, hey, wait a minute. This case is so connected to another country's legal system that we have to look at their laws to get this right. It's all about navigating that tricky intersection where different legal worlds meet.
Okay, so when we talk about a marriage that has a foreign element, the law does something really important. It splits the idea of a valid marriage into two distinct parts: its form and its essence.
So here's how to think about it. Formal validity is all about the how. It's the external stuff. The ceremony. Was it done correctly according to local customs? Were the right documents signed? That kind of thing. But essential validity, that's about the who. It goes much deeper. It asks about the fundamental legal ability of the two people to marry each other in the first place. Are they old enough? Are they too closely related? Is one of them already married?
For all the formalities, the how, the guiding principle is a Latin term, lex loci celebratonis. It just means the law of the place of celebration. So, if you follow all the procedural rules for getting married in London, then as far as the form goes, your marriage is generally considered valid. Simple as that.
But for the essentials, for the who, the law looks at something totally different. It looks to the lex domicili, which is the law of the couple's permanent home, their domicile. So let's say two 16-year-olds from India fly to a country where 16-year-olds can legally marry. Well, even if the ceremony is perfect, Indian law, as their lex domicili, would probably say they lack the fundamental capacity to marry in the first place.
And as the great scholar R.H. Grayson summed it up so clearly, the where governs the ceremony, but the who is governed by the law of your home. This distinction is absolutely fundamental to understanding everything that follows.
Now, let's flip to the other side of the coin. What happens when a marriage ends? What if an Indian couple gets a divorce in another country? Is that the end of the story? Oh, not by a long shot.
This brings us right back to that puzzle from the beginning. Is that Nevada divorce decree automatically valid in India? The short answer is a big fat no. It is not automatic. Recognizing a foreign divorce isn't just a rubber stamp process. The Indian legal system is going to take that foreign judgment and put it under a microscope.
And the main legal tool for that inspection, that microscope, is Section 13 of India's Civil Procedure Code. This section basically lays out all the conditions a foreign judgment has to meet before it's considered conclusive. It acts as a gatekeeper, making sure that foreign decrees meet some very basic standards of justice and fairness before they're allowed to have any effect in India.
So what is this gatekeeper, Section 13, actually looking for? Well, it gives us a really clear list of exceptions. Basically, a checklist of reasons why an Indian court can and absolutely will refuse to recognize a foreign judgment. This checklist is what the Indian courts will run through. They're going to ask, was the foreign court even competent to hear this case? This is a huge one, and for marriage it usually comes down to domicile. Was the case actually decided on its merits, or was it just a quick procedural thing? Was it gotten by fraud? Did it violate what we call natural justice, like was one party not even notified? If the answer to any of these is yes, then that foreign decree is not getting recognized.
And this point about fraud is so important, especially with what people call divorce tourism. So if someone goes to a place like Nevada and only pretends to live there just to meet that minimum residency requirement for a quick divorce, well, an Indian court can look at that and call it a fraud on the foreign court's jurisdiction. And that alone can be enough to say that the divorce decree they got is totally worthless in India.
So all of this disagreement between legal systems where one country recognizes a divorce and another doesn't, it leads to a really serious and deeply personal legal mess.
This conflict of legal statuses gives rise to something that jurists have a very vivid name for: the limping marriage.
And as Cheshire notes, it's exactly what it sounds like. The couple's legal status literally changes depending on which country they're in. They are caught in this bizarre legal limbo. And look, this is not just some academic theory. This has devastating, real-world consequences for people. Can you imagine trying to remarry, only to find out you might be committing the crime of bigamy in your home country? Think about the absolute chaos this creates for inheritance, for property rights, and for the legal status of children. It's a nightmare. So, we have this tangled web of rules, and we have this very human, very painful problem of the limping marriage. So where do we go from here? What's the path forward for a legal system like India's?
The reality is, the current framework is really creaking under the strain, with so many Indians living and marrying abroad. Relying on old statutes and judge-made law just isn't enough. There's an urgent need for new, clear legislation. We need laws that specifically protect spouses, often women, who are abandoned overseas, and we need to get serious about making formal agreements with other countries, so that judgments can be recognized and enforced both ways.
And I'll leave you with this final thought to chew on. Private international law isn't some dusty, static thing. It has to evolve with the world. And the central question we have to keep asking is, how can we reform these laws to give people certainty, to protect the vulnerable, and to make sure that justice doesn't get left behind at the border? Something to think about. Thanks for your time.